Hi, this is Tom O'Connor of Advanced Discovery. I'm here at the 4th Annual eDiscovery Conference at the 11th School of Law at the University of Florida, along with Craig Ball of Craig Ball Enterprises.
Intergalactic.
Intergalactic Enterprises, that's right. I actually would be remiss if I didn't mention our two hosts, Bill Hamilton from the law school and George Socha from the EDRM, who have been kind enough to kick things off today. But our first speaker of the day was, in fact, Craig, who talked about things that attorneys need to know in e-discovery. Boy, there's a wide open subject. You referenced towards the end of your speech, Craig, the most recent California bar ruling, and I just finished interviewing Michelle Lieberman of the local county and the 8th Judicial Circuit Bar, talking about changes Florida is going to make to require, answering one of the questions on one of your slides, who's responsible to do this? Florida Bar apparently is going to say they are and make technical training a CLE requirement, an MCLE requirement, 3 hours for every 3-year cycle, so an hour a year basically. Which is great news to me, and this is the first time I've heard of a bar stepping up to do that.
And you have no cynicism about this at all.
I have plenty of cynicism, but there is also plenty of time for that to come forward.
Hope springs eternal.
Manifest itself. I mean, at least a bar association has recognized, I mean, we've talked about this before offline from this recording, where it's very nice of California to say this is a requirement, and then gracefully step back from any duty to train you on the requirement.
It's a suggestion of what could be a requirement if you felt like doing it, and that's about as strong as it is.
Right.
But it's an advisory opinion. They didn't actually use the words take it or leave it, but the idea is, hey, I'll take it.
Yeah.
It's better than nothing. It's a step in the right direction. It's a baby step, but it's a step in the right direction.
And now the Florida Bar Associations, apparently they've actually sent it to the state Supreme Court, so it's up to the Supremes in Florida to just sign off on it, which according to Michelle is going to happen any time now. So there will finally be at least one state that says, yes, you need to get training in this specific area.
I believe.
So next step, baby steps, next step, right?
I understand, and this is just rumor, that Florida actually sent some people to California. That's for the purpose of being observers to make sure that fire and brimstone had not actually rained from the heavens when California said it might be a good idea to know how to do these 9 things if you're going to handle a case involving e-discovery. The absence of fire and brimstone was enough to move Florida
To
to
let
feel
them move
safe.
forward.
Yeah.
They felt confident they
Absolutely.
could do that. Yeah. Well, I mean, I like the fact, again, baby steps, that California at least listed 9 things, as you commented in your opening remarks today. The previous standard was a keep up with technology proviso from the ABA.
No, it's just keep up with the risks that may be
the risks associated with technology. Yeah, there's a
Could
good
we
one.
water it down any more and you know and still bottle it as bottled water? It's a step in the right direction, and the 9 things are actually fairly well thought out, well conceived, and so I consider it a positive step. Anyone who hasn't looked at the advisory opinion from the California Bar and the 9 things, and I think you and I would agree it's 9 very common sense things, but it boils down to a simple rule, Tom, and that rule is either learn it, get help, or get out. That's it.
And interestingly, I asked Michelle about that. She said that they are going to impose a similar change to the rules for the state bar in Florida without the third one. It's going to be learn it or retain somebody who does, but they're not going to bring up that don't take
But heaven forbid you shouldn't get business out of it.
Yeah.
Look, my problem with this is that the bars can set the requirements, but unless the bars and others also step forward and both enforce those requirements in a meaningful way, and more importantly, put forward serious, rigorous educational resources that make it possible for people to acquire this knowledge as postgraduate, post-bar passing, then it's window dressing.
Yeah, well, hopefully, again, California took the first step. Florida's taking a step with regards to education and making that mandatory. Hopefully other states will follow suit. Anything going on in your home state of Texas? I know you have your ear to the ground of trends in Texas, which makes it hard to really do anything with your ear to the ground, I think. But how do you learn
Does
anything
put me
in
in
that
a rather vulnerable position,
Yeah.
especially in Texas. So,
Yeah.
well, there's nothing going on in Texas from the standpoint of a serious movement afoot to increase accountability in lawyers for competence and e-discovery. And I don't single out Texas for that.
No.
Here, the problem is a very simple one, Tom, and I mentioned this in the keynote speech. As long as the individuals charged with setting the standards for competency are not themselves competent in this area, they will never be so bold as to draw the circle of competence in a way that they're not standing right in the center of it.
Yeah.
And so we really need the passage of time for those who refuse to become competent to simply shuffle off this mortal coil, as Shakespeare would say, and for those who are coming up in the ranks and hopefully will be more competent to be more inclined to say, I learned it, I think others should learn it as well. And like I say, we're still years, unfortunately, from that place.
I do see making it a CLE requirement as a big step. I know at Advanced Discovery we do a lot of CLEs, and I offer a large menu to select from when we're talking to people. And although the new ruling from California and technical competence is on that list, it's rarely selected. Without some compulsion to get that training, I think you're right. People are not going to go forward much on their own. So we'll see. One minor point, maybe not so minor, I want your opinion, on the California opinion. They specifically say in a footnote that they are leaving any discussion about litigation holds out of that entire arena. Do you think that's a deference to the federal rules? Do they just view it as a completely separate set of knowledge skills? I was kind of puzzled by that.
Well, I think there's several things afoot in that. First of all, the obligation to hold information does not have a statutory origin, does not have an origin in the rules. It's a common law obligation of long-standing, easily since the 1700s in Britain. So I think they...
So it's as old as the All Writs Act?
Well, nothing's older than the All Writs, and nothing is more important than the All Writs Act, Tom.
Okay.
But
we had to get that in there somehow,
We did.
right?
We have to. So the thing is that I don't think they wanted to mess around with the stream of judge-made law in this case. So it's still an evolving obligation in terms of anticipation of litigation and when that attaches and what steps bring it. So I think they didn't want to go down a slippery slope. I wasn't privy to those communications, so I'm speculating, but that's my speculation, is that there's an evolving body of common law. Let's not try turning that into a specific written obligation, because we're only going to screw that up. And I think that's true.
Okay. Any other comments in general about this field, or
What
life
field
in
were we
general?
talking about?
Yes, the left field. I
Life
think.
in general. Well, as you know, Tom, I've moved part-time to your fair city.
Yes.
And that's one of the great developments for me of 2016, is being able to be part of your city in New Orleans, Louisiana. So I think we need to encourage people. We like to believe that New Orleans is increasingly going to be ground zero, the center of the world where electronic discovery is concerned. So come on down. Nothing says technical sophistication like Louisiana.
Like beignets and iced coffee.
There you go.
Well, that's all I have for Craig.
But no, Tom, I'm going to turn the tables on you now.
Uh-oh.
I'd like you to answer some of the same questions. Enough about me. What do you think of me, Tom? Seriously, let's back it up. What's going on in your world of e-discovery? What's going on in Louisiana in terms of attorney competence when it comes to electronic evidence?
Well, I think we're like most of the states, that there's a small group of people who are very well versed, and not necessarily always at big firms. There are small and medium-sized firms. And solo attorneys who know the area very well. I think also, like many states, and something that's often overlooked in conferences like this, is the small practitioner, the small case. You and I have talked about this. We're actually having a discussion. I think we can leak it as a little teaser for the audience about trying to update the book we have on e-discovery for small cases, currently available from the ABA. And I think often those small cases and as the National Center for State Courts has said several times over the last few years, the number one case type for e-discovery requests, just by type and number of requests, is domestic. Although there are large domestic cases, it's not the big multi-state, multinational 70 terabyte case. It's the still sizable in terms of electronic data, but
it's still a great hurdle, not a volumetric hurdle, but it's you still have to deal with a cell phone, you still have to deal with some computers.
And that's what's interesting is
social networking.
It's dealing with areas that are at the cutting edge of what we're doing, or folks like you do, especially in forensics.
No, in this area, Tom, you couldn't be more right. The cutting edge is consumer data, consumer tools. You're dealing with Alexa, the Amazon Echo, Siri. In a sense, this is one of those times where the corporate world is kind of the stodgy old world approach, and it's the consumers who are pushing the envelope of new applications.
I absolutely agree, and that's what I see as not just where we're going, but it's also exciting. It's new technology, it's challenging. I know the forensics team at Advanced has seen, as I'm sure most forensic people have seen, a huge increase in requests for cell phone recovery, and I have to laugh because really you can't say cell phone recovery without laughing these days, can you? And I won't point fingers in any three-letter government agency in particular. But
FBI, okay, yeah. Sorry.
But certainly cell phones and social media. The demand for recovery of those two types of data is huge, and it's daunting, it's challenging, it's constantly evolving, and so for that reason, I think in our case, both of our cases, it's fun.
How are corporate clients dealing with mobile devices and these new tools, the Internet of Things?
Well, I think with mobile devices, it's a real problem. It's what I call the Tom Brady conundrum. When you give an employee a phone which he uses for allegedly nefarious purposes, and how do you control that? Well, they can't. They find out about it, like all of us, after the fact, and then what do you do? With social media,
there is gambling in Rick's Cabaret? Who knew? Thank you for my winnings.
I'm shocked to hear that. In terms of social media, I think corporations, at least the clients we talk with, and even firms who are our clients, are just really cracking down on no internet access, no capability to go out and access social media.
So who are they employing? Nobody under the age of 60, I assume.
No, they're employing people who are extremely adept at getting around restrictions like that.
Yes, they keep pushing the bubble in the plastic.
Exactly, which puts them at even greater risk, I think so.
But the general counsel sleeps at night being able to stand up in front of Congress or the judge and say, oh no, Judge, our people don't use phones or messaging. They live under a tin panel in the desert.
We have a strict policy against behavior of that sort. I'm shocked to hear this blog posting going on in my establishment at lunchtime.
Yes. You went to Google. We don't allow that.
Yeah.
No, I hear you, Tom. But at some point, though, we're going to have to wake up and smell the coffee, right? I mean, the chicory coffee, of course. But it's pretend. It's total pretense, isn't it? That we tell them that they don't use these devices, and so we turn a blind eye to it.
Exactly. I think that's what's going on. It's difficult to enforce. It's troublesome. It leads to problems with personnel, and certainly if you're a union shop or you have organized labor, then you're going to lead to more tensions, which no employer wants.
Okay.
So it's just a difficult scenario, and it'd be interesting to see how it plays out. I think what we'll see, and I'm seeing just a touch of this already, is more and more dumb terminals, which can't do anything.
I got you. Moving to the cloud, essentially.
Yes, but once again, I think we're talking about employees who will be very, very adept at finding new and unique ways to get around those restrictions. That's what we do. That's what human beings do. Sometimes we just can't help ourselves.
Well, we'll probably find that the FBI relied upon a
17-year-old Ukrainian kid, right?
Hackers that got them where they needed to go.
Hey, did you guys try this? And they're all looking at each other like, oh no.
Put it on the charger. Why didn't we think of that? No wonder the screen was black.
That's it. We were talking last night when a bunch of us were outside chatting about the different improvements to our life and to social life in general that technology has brought us over the last 20 years. And I'm hopeful about that. It's exciting. I feel like we're living in a time that is analogous to having lived during the middle of the Industrial Revolution or post-Civil War America, where new technology is coming in and people are finding good and bad ways to use it, but it's a time for social change, and that's exciting.
The automobile got us places, but it also polluted the atmosphere and led to a lot of unwanted pregnancies.
That's right, that's right. So, and on that cautionary note, I really don't want to say anything else on tape.
Be safe, boys and girls. Well, let me add one more thing.
Yes.
This out of the blue.
Yes.
2-year time frame. What do you think is going to be the most observable and significant change in the practice vis-a-vis electronic evidence in the next 2 years? And after you give me 2, I'll invite you to bring it out as far as you want to bring it out.
I am hopeful that. I do not know if this will happen, but you know my passion for access to justice and extending technology beyond what I see as a social niche right now to all levels of society. I am hopeful that it will extend to the underrepresented, not just in the lower class, but the middle class, and we'll see low-cost e-discovery that's available to everybody on demand. And I'm not sure if that's going to be vendors in the market or if that's going to be operating systems by people like Microsoft or Oracle, more Microsoft and Apple, I think, at the consumer end. I'm confident.
Or it may be Amazon, it may be Google.
That's right.
As we consider that local operating systems will become increasingly
cloud-based,
relevant.
yes. So I think that's what we're going to see is an ongoing extension of what is now a market dominated by big cases and high budgets. We're seeing it spread down, especially in the domestic world, but there's a whole other realm of middle-class Americans who are not using technology, who are not even using lawyers. So of course they're not doing e-discovery. I'm hopeful that technology will expand into those areas.
Well, Tom, let me thank you because you keep that need for keeping the doors of the courthouse open to the least enfranchised among us, always at the forefront of your conversations, and I think we'd agree that that is often too lacking in the high-level discussions of the millions and billions of dollars that go into e-discovery. We got to look out for the little guy too.
Okay,
Thanks,
thank you.
Tom.